Okay, welcome everyone to the final seminar in the series of Startup Know-How panel discussions offered by ISLE's Venture Development in collaboration with the UMass Amherst Technology Transfer Office. Today we will be discussing what university researchers need to know about IP strategy before they create a spin-out venture. For those of you who do not know me, I am Lisa Korpieski, the Director of Communications and Marketing here at the Institute for Applied Life Sciences. And just a few housekeeping items. This seminar is being recorded. If you miss any part of this panel discussion or would like to forward it to someone who could not attend, there will be a replay of this and all previous seminars in this series on our website. I will put the link in the chat. I recommend you set your view mode to speaker. Please stay muted during the talks. We will save the Q&A until the end of all presentations. During that time, I welcome you to unmute yourself and ask your question. You can also put questions into the chat. And thank you to everyone who submitted questions ahead of time. We will do our best to answer all of them. Next up, I would like to introduce you to our moderator, Paulina Borrego, who is the Patent and Trademark Research Center Librarian, as well as a Science and Engineering Reference Librarian here at UMass Amherst. And now I hand it over to you, Paulina.
Thank you, Lisa. So welcome everyone to the third in the series Startup Know-How panel discussions. Today's topic is what university researchers need to know about IP strategy before they create a spin-out venture. As Lisa said, my name is Paulina Borrego, and I will be today's moderator. For those of you who don't know me, I am a science and engineering librarian, the Mass Aggie Seed Librarian, and most relevant here, the UMass Amherst Patent and Trademark Resource Center Librarian. With support from the United States Patent and Trademark Office, I help regular people understand the patent and trademark application processes, teach people how to search the various systems, and point people to available resources, all for free and virtually during this pandemic crisis. So reach out if you want some help. Let me introduce today's 5 panelists, after which they will each have 3 to 5 minutes to provide some insights into today's topic, and then we will move to the question phase of the presentation. So here are the 5 panelists. Burnley Jaklevic, Burnley is the Interim Director of UMass Amherst Technology Transfer Office. She's been working in the field of technology transfer for 12 years, first in the licensing office at Texas A&M and now at UMass Amherst. She has a PhD from the Department of Molecular, Cellular, and Developmental Biology from CU Boulder and spent time working as a postdoc at CU Berkeley. Burnley worked on the Human Genome Project for 3 years before going to graduate school and is a co-inventor on a patent licensed to a university spin-out founded by her graduate school advisor. Welcome, Burnley. Next, Tani Chen. Tani counsels clients in patent prosecution in a wide variety of areas, including batteries and fuel cells, drug delivery, nanotechnology, chemical processes, biomedical engineering, and analytical devices. That's a lot. He has a particular focus on startups and university work and has helped companies develop strong IP protections based on their business goals and potential threats from competitors. Tani received a doctorate in chemical engineering from MIT in 1999 and spent 2 years as a postdoc research fellow at the Center for Engineering and Medicine at Harvard Medical School, Massachusetts General Hospital. He started working at Wolf Greenfield in 2001 and received his law degree from Suffolk in 2006. Welcome, Tani. Next, Nayla van Dessel. Nayla started a UMass spin-off company, Ernest Pharmaceuticals, with UMass IP engineering bacteria to treat solid tumors. Nayla is a bioengineer with training with a PhD in biomedical sciences from KU Leuven in Belgium. She did a postdoc with Neil Forbes in chemical engineering and co-founded Ernest Pharmaceuticals along with Professor Forbes to commercialize the IP being developed in the Forbes laboratory. Welcome, Nayla. Next, Stephen Willis. Stephen is an experienced executive and entrepreneur in the tech space. He co-founded and the pioneering internet router company, Wellfleet Communications, eventually becoming Bay Networks, and co-founded Argonne Networks, a maker of internet core switch routers. He is an advisor, board member, and investor in ventures covering machine learning, cryptographically secure auctions, collaborative software development, wind towers, neuroimaging devices, water treatment, and secure networks. Wow. Steve has a BS and BDIC computer science from the University of Massachusetts, is a member of the Beth Israel Deaconess Medical Center, IRB, the UMass College of Computer Information Science Advisory Board, and is co-inventor on multiple networking, cloud computing, and hardware patents. Welcome, Steve. And lastly, Josh Stockwell. Josh provides advice and counsel to the UMass campuses concerning all aspects of research and intellectual property at the university, and is a registered patent attorney with the USPTO. Josh has a BS in computer science from UMass Lowell and received his law degree from Roger Williams University of Law in 2004. Before coming to UMass, Josh worked as a patent attorney at the McInes and McLean and Barlow, Joseph, and Holmes. I think those are two different ones. Welcome, Josh. So many thanks to our panelists for joining us today. First to present will be Burnley.
Thank you, Paulina and Lisa. So I'm here today to represent our technology transfer office. And as most of you might know, we are an office here on campus that's charged with evaluating, protecting, marketing, and licensing inventions that are created and developed using university resources. We are an office that sits within research and engagement, and we're a pretty small office. There are only 5 of us. And 3 of us in the office actually handle invention disclosures. Myself, and again, I have a PhD in the life sciences. My colleague Ling Chen, who has a PhD in chemistry from UC Berkeley, and also an MBA from UMass Amherst, and spent 8 years working in biotech. And finally, my colleague Tom Ferguson, who has a PhD in earth science or earth and environmental engineering from Columbia University. And Tom also has experience working in a startup company. So I just wanted to point out 3 things, and I'm happy to answer any questions as well. But the 3 things I wanted to touch on today are just to let you know that we're here to be an IP resource for you, which is especially important if you're thinking about a startup. You're going to be needing to think about your IP position. The second thing I wanted to point out is that it's always best if you come and talk to us early. It's really good for us to have an understanding of your research program and your goals. And especially if you're thinking about a startup, you know, it's good for us to know what you're thinking about in terms of goals. And, you know, we're really looking to develop a long-term relationship with you. And Nayla Van Dessel is on one of the panelists today, and she's a good example of that. You know, I've been working with Nayla and Neil for the last, well, Neil for the last 8 years, but Nayla for the last 5 years. And we touch base periodically so that I know what they're working on and any new inventions that are coming out of the research that they're doing. Because ultimately we want to have a really strong patent portfolio to license to their company, Ernest Pharmaceuticals. And then finally, the last thing I wanted to mention is don't be discouraged if we say no to filing on one of your invention disclosures. Keep disclosing to us. Just because we say no once doesn't mean that we're going to say no the second or the third time you submit an invention disclosure to us. And also, if you submit an invention disclosure and we say, well, we need a little more data before we're going to be able to file, please do follow back up with us and let us know when you have that data. We're always happy to reevaluate the invention disclosure. And that's about it. Just know that we're an IP resource for you, and we're also well connected to the ecosystem, so we can point you in the right direction, kind of as you need help in other areas. And thank you.
Thank you, Burnley. Next up, we'll hear from Tani.
Hi, so I'm Tani Chen. I work at Greenfield. my practice is about half university work and the other half is startups and spin-outs. So I sort of see this from multiple sides of this process. To echo something that Burnley said, when you have a invention or something that looks very promising, Burnley is kind of the first person you'd want to talk to. One of the things I'd like to emphasize is that she can do a lot as long as it's information that's confidential and hasn't yet made it to the public. Once the information gets out there into the public or into the public domain, it can create problems, and some of these problems are mistakes that can't be fixed. So if you're ever in doubt on anything, she's probably the first person you'd want to talk to and can help kind of navigate you through this process and how do you juggle the patenting process and when to patent with the publication process and the need to publish scientific discoveries and things like that. On the startup side, from my point of view, working with startups, and this is something that a lot of researchers sometimes can get confused, is that the startup exists as a separate entity, and it basically has its own goals that are different than a university's goals. Because of that, it often will need its own IP advice and can't necessarily rely on or use a university's lawyers. The folks in the tech transfer offices like Burnley are kind of used to this sort of thing of, when do you need university sort of legal help and when you get to the point where you're becoming a spin out and you might need some outside help as well. Again, this is things that as you sort of go through the spin out process are things to keep in mind and keep the conversations going with people like Burnley at the tech transfer office to make sure that you're navigating those correctly. My third point here is basically, the reason we care about these sort of things is not because patents are kind of good in a nutshell and all you really do is count the number of patents. The reason we care about these things and IP in particular is because it's an important, necessary part of the business strategy. When you look at whether you should file a patent on it and what the value of it is, it's not the value that it brings to the scientific community or the value it brings to academic research. It's really a commercial question of, is this something that's going to become part of a business strategy that could become the foundation of a startup company, or maybe it gets licensed to a larger company. But it's really made the decision largely on the basis of commercial interest rather than scientific fundamentals or things like that. As you sort of go down this process and creating a spin out, sometimes it's important for the researchers as well to know that these are things that are different than scientific things in terms of where your business strategy is and how you can use IP to stop competitors, protect their investments, and things of that nature. And so for those of you who are thinking about going down this pathway of creating a spin out, and I think you'll hear later on from the rest of the panel about some of that sort of thing, keep in mind that intellectual property is often one of the key pieces, and that's something that you'd probably want to have some good understanding of as you talk to investors and outside partners and things like that. The final thing is, as you sort of think about these sort of issues, is that the legal business, despite all of its trappings and glamour and things like that, it's a business like any other, and that means it's basically subject to the laws of supply and demand. So when you talk to outside lawyers out there, you'll find a lot of them. Some of them are very cheap, some of them are very expensive. And in general, the ones that are more expensive offer better quality product. They probably have more experience, they have more understanding, they can create things more quickly and make them more durable and long lasting. It's often hard for people who aren't used to this field to understand what that is, just like if you've never bought a car before, the whole field of cars and whether cars are cheap or cars are expensive, it can be a new and somewhat daunting experience. But keep in mind, it's a business like any other, and you basically get what you pay for. And I guess I'll take questions at the end of this.
So thank you, Tani. Next up is Nayla, who has experience with all of this.
I'm Nele. I'm the CEO of Ernest Pharmaceuticals. I'll go into later why I am the CEO and not the CSO, as said before, because that's also something that Josh will talk about. So when we started this research, we started engineering bacteria to treat solid tumors. Neil Forbes is also in this audience, has been doing this for over 17 years. I started working with him in 2012. In 2014, when we got a grant, we decided that the IPs and the ideas we had were something that was worth patenting. And so we wrote to Burnley, and at that point still Bob, and we said, okay, these are our ideas. The NIH is going to give us money for this. And also for those who are applying for grants, once you have a grant published and received, that is an official publication. So if you get a grant for an idea, you want to file the provisional before that gets published. So we filed it. We didn't have a lot of ideas about commercializing this, or certainly not commercializing this ourselves. Then in 2016, Bob and Burnley had been knocking on our doors quite a bit, mostly on Neil's door, who had been dreaming of commercializing his technology for quite a bit longer than myself. At that point, we basically realized that all this work in the lab that we had been doing, if we wanted it to be a technology that was successful and made some difference in patients, we had to de-risk it ourselves. So at that point, we started writing grants. Neil started an LLC, so we could apply for government funding via SBIRs to see if we could de-risk this sufficiently to gain pharmaceutical interest or other interest. At that point, so in 2018, we actually started running as a company itself. At that point, Neil's COI kicked in, so his conflict of interest management, where he could no longer be CEO. So at that point, I became CEO of Ernest Pharmaceuticals. We still work very closely on running the business. I had 2 points that I wanted to make, basically things that I look back on and think, well, we should have talked about that a bit more. First is when you file a provisional, envision how the technology will be used, because that's going to inform what you're claiming and the breadth of your claims. We did not do this in 2014. We had the R1, we had this envision. If I could go back now, I would certainly make a lot more claims and try to make them even broader. One of the things I wish we'd done at that point is go talk to some people that are going to use your technologies. In our case, oncologists, and like envision actually how it will be used and make that thought experiment of what needs to change before it can go to market, before you file that patent. Even if it's a foundational patent, even if it's a basic technology, it will raise a few questions that you might be able to address with your claims. And then second, where do you need the patent? Currently, our foundational patent is US only. When we patented this, we had no idea that we were going to develop this and need funding to do this worldwide. So it was never pushed for. And I think in hindsight, now, of course, we wish it would have been worldwide, and we're having to patent around it and putting those worldwide to protect that initial IP. So I think, like, keeping that in mind, do you want to go worldwide? Also, it's going to cost quite a bit more. You have to raise those funds. How can you do that? Those, I think, are questions that you have to start having once you file a provisional. So I think those two hindsights I wish I had when we started this whole process in 2014. And with that, I will give the word to the next presenter.
Thank you, Nayla. Next up is Stephen, who has a lot of experience with successful commercial ventures.
Hi, folks. This is where I want to be, not where I am. I'm a member, for this particular discussion, I'm a member of the Maroon Venture Fund, which is a funded fund.
What? I'm listening to something, sorry.
Amherst-based, UMass Amherst-based fund interested in investing or focused on investing out of UMass technology. And so I sort of briefly talk about sort of how we feel about patents. A couple of very good points here. One was Tani's, which was that, in fact, all this patent stuff, as an investor, it is part of business strategy. It's not separate. It needs to be thought as part of the business strategy. But most importantly, I want to really encourage people to talk to Burnley as soon as possible. In that, in particular, Burnley knows the TTO knows the correct steps to make and can guide you, provide excellent guidance in sort of how this works. And from an investor point of view, I look to Burnley to give me a good package of what the intellectual property looks like. And so I really need to encourage people to go talk to Burnley first. A couple of other good points. One is disclosure. I'm interested in making sure that you have intellectual property. There's no disclosure issues that come out of that. That is, again, I'm looking for IP that's differentiable and that provides a barrier to competition. And by writing a paper or disclosing that before you find a provisional, sort of defeats the purpose of having this a barrier to competition. So I'm interested in that. Another point that Nele made was that I'm also interested in a broad patent for the technology, and that trying to have a broad set of claims that may be a slight reach of what you want to do, it is worth it for us. The secondary applications, things that you are thinking about or have investigated, I'm interested in that. The broader the set, the more protected you have, the more differentiation that you have. That's important. I'm also interested in making sure that the deliverables for the business, for the startup, are aligned with IP. It's not necessarily a bolt-on for the IP for me as an investor, but it has to be aligned with what the startup's goals are, how much money you're raising, what your deliverables are, what your business model is, what your ultimate deliverable, and what the business is. So I'm looking for that alignment in that. I'm interested in pretty serious, if you're in the process of doing this, I'm interested in kind of a very well-written provisional. Okay, I don't have to necessarily invest in patents, though that's great. But if you have a provisional, I'd like to see it fully done and generally complete and in the process. And I think that kind of gets me, certainly you issues about claims as they come back, but it certainly gives me an issue of sort of the depth and what you're kind of after. I try to read all the patents that I get. I don't necessarily understand all of them, but I try to do the diligence on all of them to get a rough feel. I'll ask other people who are domain-specific experts to look at the patents to help me, or to look at the provisionals in particular. I'm not interested, I'm sure everyone has really great ideas. I'm only interested in provisionals. I'd like to stay away from sort of your proprietary technology because, again, I don't want to be a part of a disclosure problem or disclosure issue here. Another thing I'd like to see as you file as a provisional, or a patent application is any peer-reviewed publications that you have about your technology. So some other way of backing up what you've claimed, some other thoughts that you've made, but again, not making sure the provisionals are taken care of. And I'm interested, of course, and this is for Burnley, reasonable licensing terms. And so and those are all to be negotiated. We've had fabulous discussions about that. But again, I'm interested in having a reasonable set of licensing terms. And everyone is generally sort of reasonable, but from an investment point of view, I'm interested in, equity, what the equity is going to cost me, what any royalty payments are going to work out, and a whole set of terms. Very interesting, sort of important for the business. And that's why I suggest that you talk to Burnley as soon as possible to basically, so that we can all have a sort of a discussion about the terms. There's one last thing that actually Nele just touched on a bit, which has to do this, which is conflict of interest in this. And that's also important, and it kind of fits in a little bit with IP and it doesn't, is making sure that any conflict of interests issues that come up about affecting the researcher's role with the school or with the institution are sorted out, okay? And they can be sorted out, but I as an investor, I like to see those sorted out and not necessarily, because I think that's a surprise to everyone about what people can and can't do. I also want to say that there are ideas and ideas that aren't necessarily that are worthwhile, that aren't necessarily licensable by the TTO. Okay, if you have a grant work that you do through the NSF and there's open source, that's an interesting technology I'm interested in. But ask Burnley. Okay, I'm going to just tell you that she can make the decisions about what's licensable and what's not. Thanks.
Thank you, Stephen. And last of our 5 panelists is Josh, who serves as counsel for the 5 UMass campuses. Thanks, Josh.
Thank you. So I am a university lawyer, and so I represent the university. As a faculty member, I can't represent you specifically, but I can help you as with your duties as a university employee. And so I frequently work with Burnley and faculty on any number of agreements that they might be working on to advance their projects. This could be whether you're trying to get something patented, or whether you're trying to get sponsored research dollars, and ideas like that. To touch on what Dr. Willis just spoke about, management of conflicts of interest is a big part of what I do here at the university. So we have a whole conflicts of interest policy that you should read and be familiar with. You have to disclose any financial interests that you may have regularly through the sponsored research office to Jen Donay and Mike Malone about your financial interests that may intersect with your research that you're doing, so that we can properly manage them. And a lot of the management conditions aren't insurmountable. A lot of them are fairly straightforward. We want to make sure that we're disclosing that you might have a financial interest, and this helps protect your reputation, the university's reputation, and ensures the public can trust the research that's coming out of the university. There's a process for it. It takes some time, so it's better if you disclose early so that we can queue things up to get the necessary approvals in place and management conditions in place. One of the things that you should appreciate that if you're thinking about doing a startup is it is a whole second job. And so to appreciate your limits and your time commitments that you have to do your faculty work, your research work, and possibly lead and form a new startup venture based around some technology that you're still trying to develop in your lab. It's a very time intensive, and there's a huge learning curve to a bunch of different aspects to doing a startup, whether it's trying to raise funds, to getting stuff patented, to just managing a company with employees is a really tall order for a lot of people, because usually you might have 3 or 4 staffers doing it. Of course, when you're doing a startup, you're initially on a shoestring budget, so you might not have a lot of things to worry about with this. But I would strongly suggest that you think about the structure of your company that you're thinking about forming, and resolve some of these issues, even uncomfortable ones, with like your co-inventors about, what shares of the company you're going to owe ahead of time to make sure that you're headed down the right path and not kicking the can down the road on important decisions that could cause strife between all of you. It's better to get that out earlier. A lot of those structured company documents, what they are is they're sort of like a prenuptial agreement between the founders. And if you can resolve that stuff ahead of time and have the right structures in place, it will save a lot of heartache and headache later.
Thank you, Josh. And thank you to our 5 panelists, Burnley, Tani, Nayla, Stephen, and Josh. A wide range of experience with IP and representing the university at different levels. We will now move into the question portion of the presentation. So put your questions in the chat and we will get to those. First, let me address the questions that were submitted in the registration form. So here's the first question that was submitted. What sort of restrictions, if any, should we have in internal discussions within lab groups among non-inventors of potential IP? So Burnley, that seems like a question that came from a faculty member, so I'm going to give that to you.
Okay, sure, but I'm happy for the attorneys to jump in here too. I mean, I would say in terms of a public disclosure, if you're discussing it with your fellow UMass researcher, it's not considered a public disclosure if that's what the concern is. And lab meetings are a great way and internal discussions are a great way to generate ideas. So I wouldn't want to discourage you from talking about things internally. But I'd be interested to hear Tani's perspective on that and Josh's perspective as well.
Josh, do you want to go first?
Sure. As far as public disclosure, you want to, it shouldn't be with anybody that's not, does not have access to your lab legitimately. All of the graduate students that are working in your lab should have signed participation agreements and will be bound by confidentiality provisions. You get into a sketchier area when you're having undergrad students, but there should be procedures in place for if you have undergrad students working in your lab, that they should know that they're under confidentiality provisions too. But generally I would avoid discussing confidential material with undergrad students simply because we don't have the same obligations that to the university that graduate students do and employees of the university do.
Yeah, from my perspective, I guess I would say there's sort of two things, and I completely agree with everything that Josh said. One is that you want people, you know, at the meetings to have at least some understanding that everything at that meeting is going to be confidential. Within the lab, that's typically expected. You're not going to go blab about each other's, you know, work before it's ready and before you've done the necessary controls and run all the tests and so forth. But there should be at least that understanding there. The other issue that I've seen a couple of times is what I call the leakage problem, of that people forget these sort of things and then mention it to their friends, or they go to a scientific conference and talk about it there. You know, and sometimes it's just people get excited about what's going on in the lab and they forget these things when they go out and, you know, go to the conferences or panels like this one and so forth. You know, and you know, you can have the agreements and stuff in place, but it's something you have to just remind people to make sure that everything stays in the lab, and, you know, before it's ready and before you're ready to do the big scientific publication, that you keep everything under wraps until that point, you know, and if you're going to patent it, of course, before the patent gets filed.
Let me just add one more thought to that. If you are going to go to a presentation and, you know, and this might be in advance of a publication, it is important to provide that to Burnley, because we can, on very short notice, working with outside counsel like Tani, get a provisional on file the same day as your presentation and be protected.
Yeah, I can say I get one of those fire drills about 3 or 4 times a year from one of the universities I work with. So it's pretty common in my life to end up with one of those situations.
Okay, so let me, sorry. Let me just go to the last question that was submitted in the registration form. And so I'll pose this to Steve and Josh, I guess. It says, can software be patented, or is it best protected via copyright registration? And along with that, one of the questions that was submitted was, can you patent an idea for a website? So software, copyright versus patents, and then can you patent an idea for a website?
I would say talk to an attorney, which we do in fact have here, so we can ask them.
What I would do is file on it anyway. It really kind of depends on what it is. We do know there is some stuff that is not patentable. There's just not enough there. You get overlapping protection with copyright and patent, so you can do both. For software, it's kind of fortunate that you can do that with software. So we can file a copyright registration for it. We can also file a patent application for it. And the law is in huge flux right now over software, and also like some medical procedures and biological treatments are getting very close scrutiny by all the courts at all different levels, and Congress too. So because it's in such flux, it's better not to assume that it may not be patentable in the future. And since it takes a couple of years for this stuff to go through, we might as well file on it and see what happens. You know, there's lots of patents right now that were filed 10 years ago that have been invalidated because of court decisions that have come out a year or two ago, simply because of the nature of the material of how they claimed it. So I don't want to, when you have so when we do file on patent applications, we want to try and claim it in a variety of different ways, because we just don't know what's going to stick in the future. And so, you know, attorneys like Tani spend a lot of time thinking about this sort of thing, and will have a variety of different claim sets and claim strategies for how they're going to go about claiming this thing. Because a certain strategy they may be good today may not hold up 7, 8 years from now. And you just can't tell. So you just throw it at the wall and see what sticks.
So,
Thank you.
so just a small comment about that, in that as an investor, we sort of think about trying to stay away from litigation about this, and with in the sense that that's expensive, and that we just assume pay money to engineers, and no offense taken to that, rather than the attorneys. And so we are very cautious about this, and we do pay attention to patent law and to software patents, et cetera, because of potential downstream issues that come up. And takes a couple of years for patents to show up. And so it's possible that you have an investment in an up and running company and you have a surprise at the end. So we try to track that.
Ultimately, I just say is the product matters more than the patent in most instances. Sometimes the patent can be more than the product, but if you don't have a good product, you're not going to have a business.
I pretty much agree with everything that Josh said. The one thing I would caution is that there's a lot of people I know, like researchers and so forth, who will look on the web to try to answer some of these questions about what's patentable and what's not patentable. You know, as Josh said, this is a state of the law that's just it's a huge amount of flux. Things that were correct, 1 year ago are completely wrong today, and vice versa. So you can find a lot of websites online that look really authoritative. They'll have lots of legal citations, and it'll look very accurate, and it'll be wrong because it was posted a year ago and the law moved on since then. So I really caution people against trying to do self-education in something like this. You'd want to talk to, attorney, or talk to Burnley or something like that. It can help you figure out what the current answer is and not what the answer a year ago was.
Okay, so with that, Lisa, are there questions coming in the chat?
Yes, we have a bunch. A lot of them about the disclosure agreements. The first one is, what training should students in the lab receive about public disclosure?
So why don't we also ask Burnley and Nayla, because Nayla was in a lab and Burnley advises faculty. So.
And part of that question someone else had is, are there any disclosure forms available for lab members to sign?
So Nayla, why don't we get your perspective first?
So I, as Ernest Pharmaceuticals, we still work rather closely with the Forbes lab. Neil's on the chat as well. What happens for us is that when we run across these problems, we almost always ask Chen. She has been super helpful with us. So when we asked what to do about group meetings, should we have joint group meetings? Should we discuss the technology together? Should the things that we learn ourselves, should we pass them on and backward? It's not per se the major developments, but also how to grow bacteria, little things you learn. And so from her, she said she encouraged that. So we look at papers together. So we indeed discussed that a lot of the stuff is not for publication. We have rules about data that goes to posters. So there's no application for posters for anything about that before we have discussed this. When we are going to publish papers, the first thing we do is contact Burnley and go okay, we want to publish this. What do we have to patent? What do we not have to patent? So I think having a good collaboration with your academic part of the founding team and working closely with Chen on what is allowed, what is not allowed. How do you protect yourself? How do you protect the faculty? How do you protect the students? Because they can be working on projects that can be published. We have SBIRs with subcontracts that have people working on them. That's non-publishable work. So I think having a very clear communication about what is happening, what are the different projects people are working on, and what can be published, what cannot be published, and what has to be discussed with Burnley is just critical.
So Burnley, are there some best practices with participation agreements and faculty and undergraduate, graduates, postdocs, things like that?
What about also non-UMass collaborators?
Oh, yes.
Yeah, you should. So you should definitely be careful about discussing your inventions with non-UMass collaborators, because that could be considered a public disclosure. And I did see something in the chat about having a form for people in the lab. I'm not sure who asked that, but I mean, are you referring to a non-disclosure form for people in your lab? I don't know if someone could unmute and just, help me understand that question. I think that was,
Sheet.
yeah. But we don't ask people in the lab to sign non-disclosure agreements, if that's what that question is about. And then participation agreements, everybody working at UMass should sign them at some point. I know when graduate students come into the university, they're asked to sign right when they start. Faculty members aren't necessarily asked to sign those right away, but once they apply for funding, OPAS will do a check and OPAM will do a check to make sure that there's a participation agreement in place.
And is there any difference if it's an international student?
If it's a UMass employee that's an international student, then they should sign a participation agreement. If it's a visiting scientist, whether that's international or within the US, they're asked to sign a visiting scientist agreement, which is pretty much like a participation agreement.
And can you find those forms on some UMass website so people can become familiar with them?
I'm pretty sure they're on our website, and I'm sure they're on others. A lot of departments actually handle having those forms signed, so they might have the forms as well.
Okay, thank you. Okay, Lisa, next question.
Okay, it says several panelists mentioned managing COIs. We had Jen Donay previously make herself available to help manage this. What are the major COIs that we should be aware of, and what about those that are not often discussed? And that's from David Sela.
Who should take this question? COIs. Who wants to take it?
I suppose I should.
Thank you, Joshua.
The major COIs you should be aware of are if you're going to do private consulting for a company. And so you're going to need approval from your department head, and also disclosure and approval through Mike Malone's office with Jen Donay usually on that. And to the extent that you have either federally funded grants that you're also working on, or if there's just science that you're working on that's of interest to the company that you might be doing consulting work for, which is frequently the case because companies want to hire people that they think are experts in their field to consult for them. So, and that's where we want to start the COI. Those are the most frequent things. You have a consulting agreement, or you have federally funded research. I guess the next area would be you have something patented, and it's going to be licensed to a private company that you're also have some sort of financial stake in, whether it's equity or consulting income. The areas that are not so often discussed, but do perennially come up and can be a problem, is if you want to have an executory or fiduciary role at a startup company. And we usually, we allow those under certain circumstances for usually shorter durations. There's a few faculty that have such roles with companies that do not have an intersection with their research at the university. And so we don't have a problem with that. But where you're doing consulting work for a company that's interested in your federally funded research, and you want to be on the board of directors for the company, that's consistently the university has prohibited that sort of activity. And so you want to steer clear of those. We have usually liberally allowed working on the scientific advisory board for a company that have them. And we also encourage setting them up if you're kind of part of the company initially. If you're the founder of a company, we allow that usually up until the Series A. So during the funding rounds, when you're trying to get your startup off the ground when you initially go public, or not. That's when we want you to step aside and let other people run the company.
Oh, wait, I'm gonna cut you off so that we can get to the other questions. So Lisa, next question.
Can research in published journal articles be patented?
So I'm gonna ask Nayla to answer this question because it's kind of to me like an order of operations question, and she has direct experience with, like, you know, you find something in the lab and you want to publish it versus going to a conference versus. So Nayla, why don't you give us your experience with that?
I don't know if it's already published. I think it's really hard to patent it unless you can add something new. From my experience, you want to patent it as soon as possible, but not too soon because you have to have enough data. So I think what we, one of the pushers for us is often been getting grant funding, because as I said before, once you have a grant from a federal agency, that is considered a disclosure. So at that point, the ideas that are in that grant need to be at least in a provisional, sent out. So for us, the major drivers for patenting are when we want to publish, or when we are knowing that we're going to get a grant. Once we see that our scores are within the range where we will get grants, the first thing I do is contact Burnley and say, what do we do? So I think for those two, if it's already published, I'm going to address that to Burnley or to Tani and Josh. I think that they know better what to have to do if it's already published. I assume at that point it might be too late.
Burnley, why don't you comment on that?
Well, Tani and Josh, please correct me, but so if the publication is actually the first public disclosure that you've made, then you actually have, in the US, you have a grace period of a year to file a patent application on that subject invention or what's been disclosed in that publication.
But would it be your best practice, Burnley, that people, before they go to a conference, before they think about putting in a, you know, any type of public format, that they come to you before they, you know, publish a paper, go to a conference, do a poster, anything like that?
Yeah, that's always our preference. We, you know, it's never too early to start talking to us.
I'm sorry.
What I can,
Well, to ask, I thought that you have a grace period for a year in the US, but not worldwide.
That's true, just in the US.
yeah, that was actually
Or maybe in a few other countries, you know.
Right.
Go
Yeah,
ahead,
that was going to
Tani.
be my point, is because at that point you have to drag in the lawyers. In general, I think this might be something I'd be interested in Steve's input on, is that if you look at the rest of the world other than the U.S., many countries don't have a grace period whatsoever. The instant something's out there in the public domain, there's basically no way to get it back. And if you're losing places like Europe, China, and Japan because of this rule, after that, if all you have is the U.S. market and you're going to lose all these foreign markets, my worry is that the value to an investor might start to go way down.
It does. And in that, I think once upon a time there were many patents that were applicable for the US market, but it's a global market. And so making sure that your patents are protected everywhere is important. And just, it is important in having and I ran out of time, but it's sort of talking about it, again, being part of business strategy is, where are you selling your product? And in turn, where are you going to deal with, what's your international patent strategy, offshore patent strategy? But again, part of the business.
Right. So what I tell folks is that, given those sort of issues that you would see from an investor, you really only have one role, is that you have to get these things filed before there's any public disclosure. And then, if you end up one of these sort of gray areas, yeah, you can bring the lawyers in and you can try to fix it. And the U.S. has a grace period, and a few other countries do, and many don't. And but if your investment at that point is not going to go anywhere, then none of these answers really matters for anything. Just remember the rule: don't publish it before you file the patent.
Yes, file before you disclose, and you'll be safe, generally.
Okay, I'm going to go to Lisa. What's the last question in the chat?
Okay. This is from a guest. I am interested in spinning off a nonprofit. How much experience does UMass have with spinning off nonprofits? And is there someone you can recommend who might give advice about nonprofits?
Okay, Burnley, why don't you take that first?
I don't think I've ever been involved in a spin out of a nonprofit.
Then we'll up the ladder and go to Josh.
Yep.
I've seen, when I was in private practice, I saw some people having the preference to form a nonprofit because they had a more of a goal of what they wanted to become. The problem with a nonprofit is it becomes incredibly hard to raise money for it. Because what investor wants to invest in a nonprofit? You might be able to get grants and donations from existing large corporations that want to fund your philanthropic vision, but getting money from the Maroon Fund would be more difficult. And so that's where you're going to have a lot of trouble with it. There's a lot of corporate lawyers out there in private practice that have set up lots of nonprofits and have great knowledge about setting up nonprofits and governance and running them. And if you need a recommendation, you can email Burnley and I privately, and we can feed you some people in your area that you might be able to talk to about that.
So Steve, do you have, I was just going to say, Steve, do you have something to add to that?
Yeah, and in that I do know of one thing I've come across where the nonprofit licensed intellectual property from the school, and they were starting a foundation or an institute, and they had raised the money, but from a, and you folks can comment on that, but I've seen that once, and it was someone's research that they decided that they felt was best used to serve, society rather than make money off of that. But in terms of licensing, it was a straight ahead, university licensing deal. It was just to a nonprofit.
Well, I think we could answer questions all day, but we are coming towards the end of the hour. So in closing, I'm going to ask each of the panelists in order they presented, so Burnley, Tani, Nayla, Stephen, and Josh, to provide just one or two closing thoughts briefly before we close up. So Burnley.
Sure. I would just reiterate to, if you think you have an invention, or even if you're not sure if you have an invention, it doesn't matter. We're happy to talk to you about what you're working on. And it's really good for us to understand, your research interests and your goals and the things that you're working on. So please do come and talk to us.
Thank you. Tani.
That was probably what I was going to say, was talk to Burnley first before you publish anything, that if there's any hint of where it could be commercially interesting, and what's commercially interesting these days, there's a wide variety of things that are out there, and including things that you might not necessarily think of. So if there's any doubt, I would say talk to Burnley first.
Nayla, closing thoughts.
Yes, I had some closing thoughts about, there's been a lot of remarks about COIs. From my experience, people are really willing to make you a company and help you with this. We've often ran across conflicts where, because I was not a US citizen and Neil's COI came into effect, we had to talk with Jen and decide what we were going to do to fix this, because sometimes there are two things that are happening and you have to choose the less wrong one. And I think that from that experience, we've really learned that they're there to help us and to push forward. And that when we have a problem, we can go to them rather than trying to figure it out ourselves. And I think the same with Burnley. Like, if you have an idea, if you have a problem, if you want to spin out technology, go to them with all your questions. They're super helpful, and don't be afraid because it seems scary or big. Just go and ask. They want you to succeed as well.
Thank you, Nayla. Next up, Stephen, and why don't you give us a shout out, some information about the Maroon Fund?
I was about to do that. So we are super interested in investing in your ideas. And the Maroon Fund has done a bunch of investment. There's 5 of us investment committee members, and we have a wide range of skills, and we look at a wide range of projects. And we have a couple of ventures in progress where we've licensed the technology from UMass. So we're familiar with the drill. And again, to pile on to Burnley and give her more work, please talk to Burnley. And one of the things that is important to us is to not have a kind of entangled IP strategy for this. And by going through Burnley and the process that's within the TTO makes it very easy and interesting for us to pursue your ideas and to invest in them.
Thank you, Steve. And lastly, Josh, why don't you close us out with your bird's eye view of the 5 campuses?
The university has a wide variety of resources to help you succeed with technology transfer and spinouts, whether it's Burnley's office, whether it's using IELTS, whether it's using Jen Dene's office to help manage conflicts or get sponsored research agreements, or and any number of offices there that help you network to be able to find the people you need to help you move to the next step. So take advantage of them. We are all paid to help you, and you don't have to pay us anything. And then when you get to the point where you need to hire outside counsel, we can make referrals to people we know, and you can use attorneys like Tani to help you get to that next level where you can get solid advice for your private company. You know, it's kind of dovetails with one of Tani's points, you get what you pay for. Well, in order to make money, you have to spend some money sometimes. And so, you know, whether that's blood and sweat that you're paying, because you'll have to do a lot of that to get your startup off the ground, because it's a whole second job for you. Mm-hmm. Realize when you need some help, use us to the extent that we can help you. And when you get enough velocity behind you, then you can start outsourcing the people that you need that are the experts that can bring you to the next level.
Okay, so that closes out the hour. I want to thank all our panelists, the attendees, and the organizers of this event. This and the 2 previous panel discussions can be found on the IELTS website. And if you have not checked it out, I highly recommend the Startup Navigator, also found on that site, that is filled with many great resources and information. You are more than welcome to reach out to all of these people. They are willing to help you succeed, to bring that great idea to the market. And so with that, I will wave goodbye. And thanks to everyone for a great event today. And be well, rest up, because you're going to need it when you make that startup go big. Thanks.
Thank you, Paulina. And thank you all for attending today's seminar. And a big thank you to our panel members and to Paulina as well for being our moderator. We will be back in the spring 2021 semester with a whole new lineup of startup know-how talks. So stay tuned. Stay healthy and safe, everyone. Goodbye.